This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today, we talk about why an insurance fraudster as a prisoner loses his suit against the sheriff for failure to exhaust his administrative remedies, and why even a creative litigation will fail because crime simply does not pay, and a prisoner acting as his own lawyer misses the prerequisites to his suit and therefore has it dismissed. Pro se prisoner Monnie Villarreal, in his pro se prisoner case under Section 42 U.S.C. Section 1983, United States Magistrate Judge Bradley W. Rath's report and recommendations recommended that the defendants Sheriff John Ledbetter, Geneva Drummond, and VitalCore's motions for summary judgment be granted, and that Plaintiff Monnie Villarreal's motion to amend be denied as moot, and the court dismiss this case without prejudice for failure to exhaust his administrative remedies. The district judge in Monnie Villarreal versus VitalCore et al., the United States District Court for the Southern District of Mississippi on June 18, 2025, adopted the magistrate judge's reported recommendations as the opinion of the court. Plaintiff Monnie Villarreal pled guilty to conspiracy to commit insurance fraud in the Circuit Court of Jackson County, Mississippi, and was sentenced to serve 5 years in the custody of the Mississippi Department of Corrections, the MDOC. In 2024, plaintiff violated the terms of his post-release supervision and was ordered to serve the remainder of his sentence in MDOC custody, where he remained until his release in December of 2024. Plaintiff's allegations stem from two incidents: an alleged denial of medical care and a purported failure to protect plaintiff from violence at the hands of another inmate. Plaintiff asserted that defendants VitalCore and Nancy Unknown committed attempted murder by depriving him of a proper dosage of insulin, by not allowing him to see a licensed doctor, and by forcing him to live with high blood sugar. Plaintiff accused Sheriff Ledbetter and Drummond of negligence and cruel punishment. He asserted that he was assaulted by another inmate with a broken wooden mop handle on April 21, 2024, and that Drummond refused to answer his calls for help. Plaintiff filed 3 grievances during his incarceration at JCADC, all of which were submitted through the normal grievance system. The magistrate judge recommended that plaintiff's claims be dismissed without prejudice for failure to exhaust administrative remedies under the Prison Litigation Reform Act. The report and recommendations highlighted that under the PLRA, exhaustion of administrative remedies through the prison grievance system is a prerequisite for lawsuits filed under Section 1983. Because plaintiff had not filed any grievances related to the alleged incidents through the ARP, the magistrate judge found that plaintiff had not exhausted his administrative remedies as to either of his claims. Since exhaustion of administrative remedies is a threshold issue that courts must address to determine whether litigation is being conducted in the right forum at the right time, judges may resolve factual disputes concerning exhaustion without the participation of a jury. Plaintiff was not a pretrial detainee facing a new conviction, but was instead a post-conviction inmate serving out the remainder of his sentence. The JCADC Inmate Handbook required plaintiff to use the JCADC grievance system and then the ARP grievance system before filing a lawsuit. The ARP was available to plaintiff, and he has never maintained or even argued that he used it to report the complaint of incidences. In conclusion, the court ordered and adjudged that Defendants Sheriff John Ledbetter, Geneva Drummond, and VitalCore's motions for summary judgment be granted, and Plaintiff Monnie Villarreal's claims were dismissed without prejudice as to all defendants for failure to exhaust his administrative remedies. If he does so, he can always file his suit again. In my opinion, insurance fraud perpetrators are well known for their chutzpah, Yiddish for unmitigated gall, and even when convicted and allowed to run free, he violated the terms of his release and was incarcerated to serve the remainder of his sentence. He sued in pro se the sheriff who ran the jail and others, claiming many vicious actions against his person and health, only to find he had failed to use the administrative remedies available to him, so his suit was dismissed, proving that no matter how creative his pleading, crime does not pay, and he had the right to serve his entire sentence without the right to sue those he complained about. This video was adapted from my blog, Selma on Insurance, which is available free to anyone who clicks on the URL selma.com/blog. You can subscribe to the blog, and if you do, you receive notice of every blog posting, usually 5, sometimes 6 a week, and you gain access to the more than 5,100 blog postings. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. They're all free. But if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.